Hi, and welcome to today's session on school cannabis policies and legal support. My name is Dustin McDonald, and I'm the Interim Policy Director for Americans for Safe Access, and I'm also your moderator for today's panel. Today, you'll hear from an expert group of panelists that will discuss with you some of the challenges to obtaining safe and legal school access, as well as their own personal efforts to change state laws and local laws and improve access for children in their community and their own children. Joining me first on the panel is Joe Rogoway, the founding member and managing partner of the Rogoway Law Group. Joe's been active in cannabis policy reform since 2004. Joe's pathway into medical cannabis policy really began with Americans for Safe Access, and then he made his way through the Public Defender's Office of Mendocino and Sonoma counties before opening his own practice in 2011. Joe's work has not only included representation of individuals and cannabis businesses in the space, but also he's been co-author to statewide ballot initiatives on cannabis policy reforms and worked also locally with local governments to improve their cannabis policies so they better serve communities addressing public health and public safety challenges. Beyond all of this work, Joe's also the co-founder of Oaksterdam University, the Institute of Cannabis Law, and is also the lead instructor at Long Beach City College's cannabis program. So welcome, Joe. Also joining me on the panel today is Joan Edelstein. Joan is a doctor of public health, as well as has extensive experience as a clinician, as well as professor in maternal and child health, as well as public health. Joan was the health services coordinator for a jointly funded program between Alameda County Department of Public Health and Oakland Unified School District, the purpose of which was to institute a number of programs which Joan did successfully to improve health outcomes for both students as well as staff and faculty. Joan is also an instructor at the School Nurse Credential Program for California State University in Sacramento, as well as a member of the American Cannabis Nurses Association. Welcome, Joan. Also serving with me on today's panel is Maureen Surin. Maureen's path into medical cannabis advocacy really began when her daughter Ashley, who suffered from debilitating seizures, was denied use of medical cannabis at schools, which led Joan ultimately to pursue a path of legislation, which was enacted and signed into law in Illinois in 2018, that law being known as Ashley's Law. And finally, also serving with me for Q&A for this portion of today's session is Jana Adams. Jana is a strong advocate of medical cannabis in Northern California. She has 2 children who are on individual education plans and has worked extensively in the community to increase awareness about the need for medical cannabis access for children at schools and address a lot of the challenges on the ground in working with schools to implement these policies. So thank you for joining us, Jana. Before we get started, I want to take a minute and talk a little bit about the background of all of these policies that we're all now trying to change. Really, where we start from is the 1970s and the Nixon administration and a heightened effort to increase enforcement of illegal narcotics. It was through these efforts that we also ultimately see the culmination and production of the Controlled Substances Act, which ended up having a corollary provision associated with it that was the safe school zones. And while the safe school zones policies were really sold to the American people as policies designed to keep children away from dangerous drugs and narcotics, they've primarily been used as penalty enhancements for people who are caught with possession of cannabis within 1,000 feet of a school. The challenge with the safe school zones policies really is trying to navigate around them in this conflict of laws environment between federal and state governments. And that's a lot of what we'll talk about on our discussion today. As we look across the country today, we see that there's a tremendous amount of uncertainty about how these programs roll out and go forward. Of the 47 states who have organized medical cannabis policies, there are only 11 that have specific policies related to school access. And of those 11, there's tremendous diversity in how they're organized. Getting back to the Safe Schools program piece, we see that some states are still maintaining their state school zone policies in alignment with the federal programs, while simultaneously organizing reforms to facilitate access. And this creates a lot of friction that doesn't really necessarily work for parents on the ground who are trying to obtain safe and legal access for their students. We see, as I mentioned, a tremendous diversity in these laws and a lot of holes in them, which is another thing we'll talk about today. Across them, you may see policies that these states have organized that provide for the school access, but you also see policies in place that are incomplete. For example, the policy may permit students to have access on campus, but not permit school staff to administer the cannabis to the student, meaning the parent or a caregiver has to leave their workday and come to the school and administer the medicine. You may also see policies in place that permit access on a school campus, but not on a school bus, which creates a problem for a child who might have a situation on a school bus where they need that medical cannabis access and can't get it. Finally, you also see policies where states may permit schools to administer cannabis on their campuses, but then also allow schools to opt out. This obviously creates a really challenging environment for parents who then have to navigate the school that their child is in, if that school doesn't permit that kind of access, and try to figure out other places where their children can get educated. So with that, that's a pretty strong overview of what we'll be talking about today. I'd like to turn it over to Joe Rogoway.
Great. Hey, how's it going? This is Joe. Let me start my video. Bear with me for a second. Hi, how's it going, everybody? Thank you for having me. So I would like to just start today's conversation acknowledging Americans for Safe Access. As Dustin noted, if it wasn't for ASA, I wouldn't be here. It was Steph Scher who first gave me my break into the realm of cannabis. Before that, I was working a sort of miserable job in Embarcadero 1, doing the type of work that I wasn't interested in. And Steph gave me an amazing opportunity that has, just been a wellspring for me professionally for the last 16 years. And so I'm just incredibly happy to be here, to be a part of this conversation, and especially on this topic. We're going to talk about generally what the process is, and perhaps if Jeff can have my PowerPoint brought up. But there we go. So we're going to talk about sort of generalities in terms of the law, in terms of the federal and state as it relates to at least California level concepts for ensuring that all children have a right to education, regardless of the medicine that they need to use. And then I'm going to conclude the presentation going to a bit of a case study into the matter that I helped with Jana and her daughter, because I think that is illustrative. And importantly, we not only prevailed on that case, but we prevailed in a way that the judge who heard the case wrote a emphatic over 20-page written opinion, not just reinforcing all of our arguments, but expanding upon them in a way that's really beneficial to the family and to the child, and really calling out some of the nonsense that the district has, that they utilize rather, for things like drug-free school zones that Dustin mentioned briefly. So we'll get into that. Perhaps let's just start and go into the next slide. Going into, so we can go to the next one. Then we have, so we can go into, there we go. So basically the concept that is really important for everybody to understand is the FAPE. And so basically every child has the right to appropriate public education. And that's important for children of all backgrounds with all various types of disabilities, that regardless of what the child may be experiencing, they have a right to public education. And this is just obviously incredibly important from a policy perspective, because without this concept enshrined into law, it's really easy, I think, for districts, for administrators to relegate children with disabilities into areas where they just don't have access to meaningful educational opportunities. And that's essentially what the district tried to do in the Adams matter, which I can describe a bit later. The way that this concept is enshrined into law is through the IDEA, which is the Individuals with Disabilities Education Act. And it is this sort of base level guarantee under federal law that guarantees the appropriate public education for all children. And so this is really the federal basis for all actions that a family may need to bring against a school district. In California, it's codified additionally through our education code. Basically, the concept that is really important to think about is this concept of due process. So obviously, due process is a constitutional concept that derives from the 14th Amendment to the United States Constitution. There's state level equivalents in California and in every other state. And basically what the mechanics are is essentially saying the child is being denied and not, their access to education. They're not receiving a FAPE. And that we have a right to utilize due process to force the district to reconsider their determination. And ultimately to bring this into a hearing in California. It's through the Office of Administrative Hearings, and they conduct what's called a due process hearing, which I'll get into in a moment, which is essentially our best opportunity as advocates, as people who are representing families and children in the circumstance, to contest what a school district is doing to a child. Because oftentimes, many of you may already know this, it's incredibly unjust and unfair and to a certain extent unhumane. And so it's something that it is worth us discussing here so that everyone has an understanding of really what their rights are and how to contest these really unfortunate determinations that school districts can make, particularly with regards to the utilization of cannabinoid-based medicine in a school setting, which a lot of districts are just unwilling to do and will force this issue. So we can go on to the next slide. So yeah, the IDEA is essentially the continuation of law that really started back in 1975, but the IDEA is a much more recent enactment. I believe it was enacted in 2003 or 2004. And as I mentioned earlier, this is the landmark seminal law that really deals with these issues. So next slide, please. This is essentially just an overview of what the IDEA does. There are some breakdowns as it relates to age. When you get to these threshold ages of newborns through 2, if you look at the second bullet point, there are the abilities for families to receive early intervention, and then there is the ability from ages 3 all the way through adulthood for special education. And so you're going to see this brought up a bit more in some subsequent slides concerning IEPs, but essentially all of this stuff, once again, is predicated on the IDEA. So for anybody interested in doing a little light reading, this is a good place to start to understand what your rights are from a fundamental federal law perspective. Next slide, please. So here is the definition of parents. It is a fairly broad definition, and so you can see how it's defined here. So it's fairly self-explanatory. I think we can go to the next slide. Here is how school districts are defined. So it's really just all educational agencies that are involved in making the educational decisions for a student. So that can include a lot of different things: the school district itself, charter schools, other state agencies that may have the ability to determine the provision of services to children with disabilities. And then, a party can be, any of the types of individuals or entities that are described in that second main bullet point: parent, person, district, educational agency, that's somehow involved in the due process proceedings. So this is really where the rubber hits the road. So many of you who have been involved in this process are probably the most familiar with an IEP, which is what the school district will do that really defines how they're going to accommodate the special needs of the child. They're written documents, importantly, There's an assessment of the student's strengths and weaknesses. There is an assessment and identification of what the goals are for that particular student. So that's where the district is really trying to understand what is a realistic educational objective that, that they can have for a particular student with special needs, and to identify those. And that correlates to what is the classroom setting going to be? What are the additional services that are going to be made available for the student? And importantly, what are the accommodations and modifications that are going to be need to be made for the student to really be successful and to be provided with their FAPE, which is what I was identifying earlier. And so fundamentally, the process is not intended to require a lawyer to help a parent do anything. You as a parent, at least hypothetically, should be able to navigate this process on your own, and to go through the process of, if needed, contesting what the IEP is, to essentially stand up for your rights, your children's rights, and make sure that they are having the opportunities of education that they're entitled to. However, in reality, that's often not the case, and it can be very asymmetrical, where you have a parent who is really just trying to advocate for their child on the one hand, and on the other, you have principals or superintendents, sometimes attorneys for the district will get involved early on, and that then gives rise, I think, especially in matters that involve the utilization of cannabinoid medicine, to bring in an attorney who knows what they're dealing with here. And there are law firms that specialize only in the special education issues. My office, my law firm, we specialize in cannabis, and this is sort of subsumed within that. But there are specialists in this field, and it's worth getting in touch with those attorneys if you think that there's an issue that you're not going to be able to handle on your own, meaning that the school district is not giving your child access to the education that they're entitled to because of their use of cannabis. And one of the things that is important to keep in mind is that, at least in California, attorney's fees can be awarded. And so this can come through the process of mediation and or the due process hearing, which I'll get into in a moment. But this is really critical because, of course, having an attorney can be an expensive endeavor. It's something that, if you go through the due process hearing itself, easily could be a 5 or even 6-figure number in terms of attorney's fees, which can be disheartening, which can be unrealistic, which is something that I think it's important to recognize that you can get prevailing parties' attorney's fees, and that can be something that's negotiated at the mediation, or something that is awarded following the due process hearing. So please keep that in mind, so that you don't allow the really extensive financial issues to be limiting in terms of how you want to address counsel through this process. And so you can also, just as an aside, have non-attorneys that accompany you through this process. I have participated in mediations before where it's not just myself, but a separate advocate who specializes more on the special education side of things, that is there and present, but that is not the quote unquote representation of the parents. And so it's sort of more of an advisory role. And you just want to make sure that if it is something that's contested and you think that your child is not being addressed properly by the district, to really consider having an attorney advocate for you, because it can make the difference in a very real and fundamental way between your child having access to education in a meaningful way or not. And we'll get into some of the sort of bizarre, contorted ways that districts can try to justify whatever they're offering as meeting their obligations to provide a FAPE, when in fact it's not. So we'll get to that in a moment. Obviously, cannabis remains a Schedule I controlled substance on a federal level, meaning that there is no currently accepted medicinal value, high potential for abuse, and very limited ability to research the medical efficacy of cannabis, which means that a lot of the information that we have is either anecdotal or it's just based on just really faulty data coming from a single farm in Mississippi that grows very low quality cannabis to utilize for whatever limited research is available. And to put this in perspective, Schedule I controlled substances are substances like heroin. So when you think about how the federal government classifies cannabis, anywhere you see the word cannabis, replace the word cannabis with heroin, and you will have an understanding as to how inane and nonsensical the federal classifications are. And to provide some perspective, you can see the bottom bullet point here. Substances like cocaine and methamphetamine are Schedule II. So the federal government thinks that cocaine and methamphetamine have less potential for abuse and have more of an accepted medicinal use than cannabis, which is absurd. So right now, as at least some of you may know, there is a case going before the United States Supreme Court. There is briefing. I know that ASA has filed an amicus brief in that matter. We'll see what happens. This relates to essentially removing cannabis out of that Schedule I status. I think, of course, all of us would prefer that cannabis was just descheduled entirely from the CSA. We'll see how the Supremes deal with that issue. And of course, this is going to be impacted by the very sad and unfortunate passing of Ruth Bader Ginsburg and the replacement of someone who may not have a particular tolerant view of the medical use of cannabis. So once again, as always, with all things cannabis, it's a hyper political issue, and right now before the Supreme Court is a pretty monumental decision that they have before them. This is, I think, just an important illustration to see where the state of play is as it relates to cannabis. Of course, this map is always in flux, and in the next month or so, we may see some of these states that have the color green, have the color blue. So keep an eye out, for example, on what happens to Montana, what happens to Arizona, what happens to New Jersey. Let's see what the governor of Vermont does, at least with regards to recreational use. And you can see where we are. And I think something that is important is that the color gray on the map is just there's prohibited all cannabis uses. And right now we're down to only 3 states that would identify in that way, which is, I think, demonstrative of significant progress that we have made since, the days when I first started at ASA in 2004. So I'm going to kind of go through some of these Supreme Court opinions, going just quickly, just for your own citations. You can see the Rowley case that is really the kind of most significant case to deal with the IDEA. And then I think more centrally, the next opinion is the Douglas County Schools case. And this is a case that we used extensively in the Adams matter. And if you look at the bottom bullet point, this was something that we actually we relied on heavily, which is more than a mere de minimis test. So a school district, their IEP may be something that, at least in sort of a very superficial type of way, will identify access to education being provided to a student with special needs. And oftentimes that can be something that is de minimis. And in the Adams matter, one of the things that the school district utilized was essentially saying that there's going to be 1 hour of at-home learning per day. And that for the important socialization skills that all children need, regardless of whether or not they have special needs. And that's an important part of the educational experience in going to a traditional school. That is something that the district in that case wanted to have resolved by essentially having play dates with neighborhood children with the student. And so it was something that is just like profoundly inauthentic to think that that was going to be adequate, that somehow Jana could just organize these play dates for her daughter, and that was going to replace the experience that she would otherwise get going through the district process. And so maybe, you know, given, it looks like I just have a couple minutes left, so maybe we can jump into the actual Adams case, and I can go into due process and mediation there. So basically, you know, I have some extra slides here for anyone's edification that wants to go through them. Due process really is effectuated primarily through what's called a due process hearing. And if you ever get to a place where you need to contest the IEP, most likely, you can probably skip to the next slide, most likely what would happen is that you would have both a mediation and a due process hearing, so that if the mediation failed, then you would have some dispositive mechanism for the administrative law judge to determine whether or not FAPE has been realized in a particular matter. And so that is what ended up happening, and I'll kind of skip, I just have about a minute left, in the Adams matter, where basically the school district took a position that was sort of convoluted, where they would tell us that they were supportive of what we were trying to do, but they felt obliged to nevertheless prevent the child from actually going to school. And so it was an awkward sort of dance, I think, that they were trying to do. Ultimately, we ended up in a very contested due process hearing. And in that hearing, we had the superintendent for, the assistant superintendent for the district testify as to some of these things that were just, you know, facially absurd, that essentially the child cannot go to school because it'd be a violation of the drug-free school zones to allow the administration of, in this case, THC oils, high THC oils, to be administered by the student's nurse on the school premise, and that they were going to require instead the school to have the parent, Jana, come and essentially be on call. It looks like I am getting the wrap it up sign. I wish I could talk to you for an hour longer. I am available for questions after the fact, but Dustin, I will hand it back to you. Thank you for your time.
Thanks, Joe. And with that, we'll turn it over to Joan Edelstein.
I'm trying. There it is. Thank you. It's nice to be here, and I appreciate being invited. If we could start the PowerPoint, I can go over what's happening in California with policy and what the implications are for school nurses. Thank you. Just go straight to the next slide. So we had JoJo's Law signed in by Governor Newsom last year, and it amended the education code 49414.1. And pardon me, but I'm not sure that everybody is going to get these PowerPoints. And should you not, my contact information is the end of this, and you can write it down, and I'm happy to send it to you because all these hyperlinks actually work. The California School Boards Association, CSBA in California, provides sample policies that most districts use, the vast majority of districts use. And what's important about this is that there's a policy that is the key one that needs to be changed in the district to allow cannabis use on the campus. It's 3513.4. It's the drug and alcohol-free schools policies, which can be revised at a district level. Hopefully CSBA will be coming out with one that has already changed that. They refer to health and safety code in the ed code because they won't spell out everything that's in the health and safety code. And then the health and safety code lists all the drugs in the Uniform Controlled Substances Act that apply in this policy. And what it basically says, if we can go to the next slide, is that students may not have, student staff, nobody may have any of these drugs, and there are hundreds of drugs listed. It's an extensive list, unless they have a prescription. And I really appreciated Joe pointing out that heroin and cocaine and meth are all included in those, which say if they have a prescription, they can bring it on campus. But the language specifically says, except for prescribed cannabis. And so what the policy says, all these can be provided with prescriptions except for prescribed cannabis. So that little phrase needs to be taken out. And also there's one section that says these substances are prohibited on all district policy, and there's a separate note for cannabis or cannabis products, which also comes from Health and Safety Code. So there's two minor changes in wording that have a major impact. Then the other piece that school nurses work on has to do with medication administration, how medications are allowed on school campuses and how they're administered and whose responsibility is what and whose role it is. And so all the information that spells out how that can happen on the campus is in that board policy. Next slide. So we can look at shaping district policy to allow cannabis administration on campus. Again, the districts are not required to do that. And what this law says is that parents or guardians may provide that medication on campus, but that means, again, that they have to come in, take time off work, be available, etc. And it struck me that there is a potential legal conflict because years ago, this diabetes lawsuit I'm referring to, this is the conclusion of a diabetes lawsuit that happened somewhere around 2003. I can't remember what year the decision was, maybe 2000, or the settlement was. What happened is DREDF, the Disability Rights Education Defense Fund, and the American Diabetes Association sued two districts in California, one of which was in my county, and the superintendent of schools, because the schools were saying, we can't provide care for your students with diabetes, you have to come in and do it. And so there was a settlement so that that didn't have to happen. But in that settlement, what ultimately was the result for school nurses is that they had to educate and train unlicensed assisted personnel, which was beyond their scope of practice, according to the Board of Registered Nursing. And this is where it's kind of important when it comes to cannabis, because nurses are very concerned about losing their license and what the Board of Registered Nursing will do. So the Nurses Association sued, saying, you didn't involve us in this settlement. You're saying that we have to go beyond our scope of practice, and we should have been involved, and we don't think we should be training people who aren't licensed to give insulin or care for these students, but it mainly had to do with giving insulin. That lawsuit went to the California Supreme Court. And what's important about that is, as Joe pointed out, the Supreme Court said, yeah, we know the districts have to provide a free and appropriate public education, and the school has to provide the care. And parents and guardians may not be pressured or required to provide the care, that the school districts had to do that. So if you could go to the next slide, please. Basically, what they said was, you don't want to require children to leave school during the day for their medication, and you don't want to make their parents have to pay extra money for a school visit by the physician, because physician was in the law as somebody who could provide the insulin. In the next slide. And the other thing that they said is, you can't have parents sign a waiver that says, my child doesn't have a right to treatment at school in order to attend. And you shouldn't have to take time off work to go to school and deliver the medications. So all this conflicts with what the law says for cannabis administration on campus. In California, it doesn't say that the school staff may not administer. They do say may not be required to administer because of discomfort. And the next slide, please. So some of the considerations for the school nurses, even though I've been talking about California, in Colorado, school nurses may administer the cannabis on campus. And that's controversial among the school nurses because they're concerned about their licenses, they're concerned about criminal action against them. And there are many school nurses who are saying, no, I'm fine giving it. Same in California, the attitude towards cannabis has changed over the years. I've been educating school nurses on access and advocacy for cannabis at schools for about 5 years now. And I've noticed a significant shift in the school nurses who are comfortable having students get cannabis. New Mexico, actually, even though they don't have school nurses administer, they provide guidance for school nurses to educate and be knowledgeable on cannabis so that there is advocacy that's provided. And finally, the National Council of State Boards of Nursing, again, we mentioned the boards of registered nursing who determine, scope of practice as well as whether somebody should be disciplined, has specific guidelines now for what students in a pre-licensure program who are being educated to become registered nurses should learn about marijuana, about cannabis. And so there is a shift in emphasis as far as what should happen for school nurses. And next slide. So this is simply my contact information, which you are more than welcome to email me. If you don't hear in 2 days, email me again so you don't fall off the radar. And I'm happy to provide any information at all. And at the end, there is actually just one last slide that simply has some useful resources in the schools. And the one other thing I did want to mention in the few seconds that I have left is 504, once again, 504 plans for students who don't have, who are not eligible for or don't need an IEP. They still have access to reasonable accommodations through the Section 504 of the IDEA, just like you do at work. So thank you so much.
Thank you, Joan. And with that, we'll turn it over to Maureen Surin.
Hi, everybody. Can you hear me?
Yep,
Can you guys hear me okay? Okay, good. Well, first off, thank you for having me. I was so excited to get this invite, and this has been the most amazing Zoom. I can't even, there's no words. This has just been amazing. So thank you. I'm here to share my story about my daughter, Ashley, who she's now 14, but at age 2, I'm already getting emotional. I'm sorry. At age 2, she had leukemia, and she was only 2.5 diagnosed with it. And within a year, that was December of 2008. And within a year, she developed seizures from what we believe one of the chemo meds, a high dose of one of the chemo meds. So at that point, she started many different neuromeds because as much as we were beating the cancer, the seizures were just debilitating. She had anywhere from 1 to 3 seizures a day, and we couldn't regulate them. And as she got closer to puberty, they got more difficult to manage. So she was up to 3 neuromedicines in 2017 when she was turning 12. And we just thought it was so much on her little body. She actually had a concussion and brain surgery in 2017, and that was a turning point for my husband and I to say, there has to be something different. Let's look into naturopaths. There's got to be something different we're not seeing. So we found Dr. Tony Bark and Dr. Donald Radin in Illinois, and they both said to us, your daughter should consume cannabis and go on a low-carb keto diet. And that really was the answer. She is now 14, and she'll be 3 years seizure-free in January on medical cannabis, this low-carb, gluten-free diet, and she takes a small amount of a thyroid, a natural thyroid pill. But I have to say it was a difficult choice because once we started the cannabis, we weren't sure what was going to happen with school being illegal in our state in Illinois for school. So our doctor wrote us a note and said, you know, I don't know how far this is going to go because the state, it's illegal in Illinois. So we said, we have to try this. This is working for her. Like no other thing is working for her. And our superintendent and our doctor and our school district said, we're sorry, there's a state law. So we decided to look into attorneys and see what we could find. And we did sue federally and won in 2018, and it brought, 2017, and it brought us to our state capitol to testify and get Ashley's Law into Public Act August 1st of 2018. And that allows medical cannabis in school for any child that needs it, that has a license. So it's been a journey. I just have to say though, it was difficult because we thought we were going to have to move. We didn't know if the legal system was going to allow us to, kind of punch through with this. Basically what happened when we went to court was the judge said, I can't help you, but the attorney said, how do we help this family? We really want to help them. And the federal judge in Illinois said, you got homework, go home and make a law. And that's exactly what they did. So it was really, really cool when we had to sue to get it into school, but it made a statement, and our daughter is off of all her neuromedicines. I think like we heard earlier on, sometimes less is more. So we were weaning off of the neuromeds and slowly moving up on the CBD to get to that perfect dose. And my daughter's been on the same dose since January of 2018 without a seizure for, it'll be 3 years in January. So it really has changed her life. She's more alert. She's reading, she's engaging, she's writing, she's processing, she's having play dates with friends, she's asking questions, she's more physically able to do things. The list goes on with the benefits of the cannabinoids. I can't even explain them all. It's really been like watching a miracle before our eyes. So I share with you her picture now. This is her now. So it's really been amazing. So we're currently trying to help with the law for camps. We want kids to be able to access it in camps. And I really wish Disney would allow it. I wish we had, insurance and rights to travel. I don't know why we can't travel around the world. This is the United States, and we're United States citizens. We should be able to travel with our medicines like everyone else. So kudos to everybody on this call. It's been a journey, but it's nice to be on, to know that other people are fighting for the same things that we are. So I don't know if I've left anything else out. Jana, let me know.
Thank you so much, Maureen. I think we've had a great discussion and heard a lot of great information from our panelists today. It's such a compelling story. the trials that parents have to go through to try to navigate school access is pretty incredible, especially in this day and age when you see you've got 47 states with some form of legal access. You don't expect when your state reforms their laws to facilitate that kind of access, you're going to encounter these roadblocks. What we'd like to do now is pivot away from the panel and move into our Q&A session, jumping right off from questions that we've already started receiving. This is from a physician that says, federal law states that physicians cannot write prescriptions for Schedule I controlled substances. My attorney has advised me that I cannot write any prescriptions for cannabis and medicines so that a child can get their medicine, THC, CBD, or any photocannabinoid. At school, as I would be violating federal law. So laws can be passed to allow children to get it, but the school nurse needs a prescription which I cannot legally provide. What do you see as the solution to this issue? This is really a question for all of our panelists.
Well, I can respond to the legal issue. So you're absolutely correct. First, that the United States Supreme Court in Cunningham v. Walters said that physicians cannot prescribe cannabis because it's a Schedule I controlled substance. So the workaround going back to Prop 215, which is the nation's first medical cannabis law that came here in California in 1996, allowed for the medical use of cannabis based on a physician's recommendation or approval. So typically that is exactly what happens, is either there is an affirmative recommendation from the physician that says, I recommend that this patient uses medical cannabis, or there's an approval where essentially the physician is assenting to the patient's stated use of medical cannabis. So that's what the legal standard is. So in terms of what you as a physician may be able to do, that is the categories of authorization that you have.
Thank you. And I can address a little bit about what can be done at the schools potentially. So as an example, what's done for Jana's daughter at Rincon Valley is that the accommodations that were made, and which can be done in the district policy for medication administration that spell out exactly what happens, is that there can be an agreement to consider the recommendation as the same as a prescription and to use the written recommendation as long as it's got all of the same information. And the original, if possible, the original vial is provided. Sometimes it's not possible, but even in prescribed medications, when parents or guardians put the medication in a pre-filled syringe, we can write those accommodations that the parents or guardians will do that. So again, I can't guarantee for every district is different as far as their acceptance, but that's one of the ways that we've been able to provide access.
I can tell you for Ashley's school, I had to fill out a seizure action plan, and the doctor just has to kind of sign off on it. But that's my seizure action plan is her go-to is the cannabis. So.
And that's the same for my daughter as well. Her neurologist signs off on the seizure plan because my daughter uses the THC as a rescue medication. And so it's kind of like an EpiPen. She needs to have it for life-saving, so they accommodated that with Joe's help winning the case. And so we're hoping that, we can make that more accessible throughout California and other states.
Dr. Goldstein, thank you for the question. I wasn't aware that the physicians were not allowed to provide specific dosing. And
That's correct. That's correct. Physicians don't provide specific dosing. It's essentially just a generalized recommendation or approval.
So they're specifically not allowed to put the dose in?
Correct.
So that's something that would have to be included in the accommodations, but that's information for me to know when I talk to school nurses.
And I should say that that's really a canard that oftentimes people that want to prevent the medical use of cannabis will say that the recommendation is somehow inadequate because it fails to state dosage, which in fact is just legally they're not able to use the dosage, and it has no, legal meaning whatsoever within the purview of California's medical cannabis laws, whether or not it states dosage or not. So just recognize when that is an argument that's presented to you that it's really just a red herring.
Yeah, and I totally get that it's a red herring, but where school nurses will run into the problem, into difficulty, is that they're supposed to be able to see what the dose is and determine if that's in the safe range. Of course, they can't determine what's in the safe range because we really don't have that information. But it's just something for us to consider.
Well, sorry, yeah, I was going to just say it's part of like the circular nonsense, because of course a safe range could be determined through extensive research, which you can't have as a Schedule I controlled substance, which also prevents the prescription. It's just a really nonsensical construct that they have.
I think another big point to make is, I'm sorry, Jana.
Go ahead.
I was going to say another big point that I know you ran into, Jana, was if any states are going for a new law for, school and cannabis, beg your politicians, your, lawmakers to make it a must allow law, because this opt out should not be, opt out of a medicine, that doesn't even make sense. So don't let that happen if you can help it with your states. Push for a must allow law that if they're trying to opt out, then they need to hire a third party, but don't let them opt out, because that's been a big barricade for Jana.
Yeah, and I know you want to say something, Jana. I just want to pipe in here that I totally agree with you. And in Florida, where they didn't say must allow, where they said the district must have policy, there were districts that fought back and refused to create policy. So just to recognize it's a challenge.
Yeah, I think in Illinois, we've had one area kind of challenge it, and I think it might lead to an amendment saying, if you're choosing not to follow such law, then you must hire a third party to take over. So that takes the burden off the parents, which is beautiful, how it should be.
Hey, Dustin, I think you're muted.
No.
No.
There's a question about anything in writing being considered a prescription. Oh, I see. Never mind. It's not. I was wondering about that.
There is a question that maybe while Dustin gets back online, there is a question that just came in concerning going across state lines for therapy. With regards to actually possessing the cannabis, obviously going into and out of states where cannabis is not legal is problematic. Just going across state lines in and of itself is one of the things that can invoke federal jurisdiction under the Commerce Clause. And it's actually through the 10th Amendment, through the Commerce Clause, that the federal government has been able to justify ongoing prohibition for medical cannabis since the beginning of everything. So even in a circumstance where an individual is cultivating their own medical cannabis, they're using it for their own personal medical needs, it never leaves the site of the cultivation ever. Hypothetically, because the cannabis could travel across state lines, the federal government has invoked their jurisdiction to prohibit it on a state level based on that construct. And so then the actual transportation of cannabis across state lines is also something that's clearly prohibited and something that people have had problems dealing with. So there's been a lot of issues, reported issues of people going in and out of Colorado from neighboring states that did not allow for cannabis, and then running into problems there. And then there is the sort of additional issue that can happen to parents, which is having some type of action brought in their locality that goes to like a CPS type issue. So if you want to have a really draconian response, you can see where that happens in some of these jurisdictions where parents, maybe have their parental rights looked at being stripped away because they allowed their cannabis to use, their children to use medical cannabis. So it's something that is fraught, and it's something that going in and out of other states, there can be a lot of problems that are attached to it, unfortunately.
People hear me now?
Yes.
All right, back to business. Sorry for the delay. Did you already run through the question, Joe, about what advice would you give to another parent who may live in a state that does not recognize cannabis use in schools?
Well, I think it's all very state specific. So the question is, what state is it? What are the larger cannabis policies in that state? And how does that state effectuate the IDEA on a local level? So it's a very sort of fact intensive type of analysis depending on where you are. But that's going to give rise to the rights that you have or don't have. So obviously in a place like California, where we have, a venerated medical cannabis regime that is now layered on top of for the last 4 years with adult use, it's a very different circumstance than if you're in, let's say, Nebraska or one of the Dakotas that does not allow for any type of cannabis use. It's going to be a much tougher sell to have something beneficial happen in one of those jurisdictions than in a place like California.
There's a question that a lot of folks have raised with respect to how parents are kind of navigating this environment. In some legal states, parents are purchasing cannabis and sharing it with their children almost as if it was an over-the-counter medication being used for, common cold symptoms, cough suppressant and whatnot, or even with respect to integrating cannabis as part of their child's treatment plan into use at school. Rather than addressing it directly with school officials, they might be putting bits of CBD in their child's water that they take to school, things like that. I guess, what's the importance of having medical professionals involved in this discussion directly with parents so they understand what their role is and what they need to be doing that's appropriate with respect to cannabis administration of their children? And then the same question with respect to integration of medical professionals into that conversation with school administrators, and having parents be direct in engaging their school administrators on the need for their children to have this kind of access. I was hoping the panel could talk about that issue a little bit more.
So the type of activity that you're describing is something that I would categorize as high risk. So I think that obviously any parent who has a child with disabilities or a catastrophic medical condition will do anything that they can to help their child, bottom line. The problem is that the way that the laws are structured, if anything happens and there is some type of test on the child to determine whether or not they have any controlled substance in their system, and you have THC, for example, that tests positive in that test, in that circumstance, then that's a very easy way for someone's parental rights to be put at risk, unfortunately. So I think that, as difficult as it may be in different places to get the medical advice and direction, and to really have it curated in the way that, someone like Dr. Goldstein would be able to do. There's just not enough doctors like Dr. Goldstein, unfortunately. And so you have a situation where a lot of parents, because of that just real lack of access, and of course, this is the premise of Americans for Safe Access, is getting safe access. The gatekeeper for safe access is and always has been the physician. And without that role, then there is a lot of risk to the parent and to the child in a lot of ways. I mean, imagine being alienated, being a young child with disabilities, being alienated from your parent and being forced to live in a different environment because your parent was doing anything that they could to help you. And in fact, maybe helping the child substantially, but just not having that vetted through the appropriate medical process. So I'd say that one of the things that is just invaluable and so important is to have those relationships with physicians who can provide the appropriate recommendation or authorization so that you're not put in that higher category of risk. That is just fundamental to this whole thing, because as a parent, you can't help your child if you're not able to be with them.
Thanks for that, Joe. Other thoughts from folks on the panel?
Yeah, that was some of the, I went and spoke at a nursing conference with Joan, and that was one of the concerns that came up with nurses at school, saying, you know, there's a lot of parents out there that are sending it in their lunch boxes and things like that, and don't tell kind of thing. And, you know, it just kind of makes them more worried about how many parents are doing that versus going the right route, to really stand behind us, trying, you know, those of us that are trying to go the right route. So it kind of defeats the purpose or hinders our efforts.
I think it also is a challenge for parents who are trying to do the right thing, as Jana mentioned, where you really need that coordinated effort among parents to approach administrators to break through the stigma around medical cannabis. I think there's still a lot of that issue hanging out there, and it does really require a coordinated effort, you know, and for parents to come to administrators and be honest about what their child's needs are and what the school's responsibilities are to fulfill those needs.
And not to put too, oh, sorry, I just want to just say, not to put too fine of a point on it, but prevailing on the case with Jana would not have happened without a lot of support from the physicians. And that is the threshold issue. But for having the physician recommendation, we would not have been tracked to go towards the due process hearing. We would have been dealing with a CPS action, which is just a very different thing. If you don't have that medical authorization in the way that's recognized by your home state, you are just at a significant risk. And I just want to underscore this, because I agree that I think anecdotally, we can all assume that there is just a tremendous amount of parents that are informally giving cannabis or cannabis-derived products to their child in some way. Even hemp-derived products, that is untested legally. We don't know what happens if there is a child who goes to school with CBD products legally derived from hemp and they're caught using that. I think we can all agree on what should happen, but there's never been a court that has addressed that issue. And what we can see is that the way that the federal government perceives cannabinoids that are derived from hemp is, I think, much more limited and in many cases much more punitive than what we may otherwise assume. So for example, the DEA has this new interim rule that says even a momentary increase of above the 0.3% THC threshold removes hemp out of the category of an unscheduled, non-controlled substance agricultural crop and puts it into the Schedule I status of cannabis. Just even if it's momentary spike during processing, or if it's momentary, or if it's a spike related to the plant, the hemp plant's getting hot during the cultivation process. So it's just something to keep in mind, that even if it seems safe, that you can go, you know, now across the country to grocery stores a lot of times, to like a CVS or Rite Aid, and get CBD products, that is not the green light to give it to your child. And so it's just important to recognize that, I think.
Really good point, Joe. Another question we had come in was related to hospitals, and this person was interested in having us address the issue of patients bringing cannabis into the hospital themselves, and talk about some of the issues around that. Says many are told that since the hospital receives federal funds, that they're not permitted to use cannabis on the grounds of that hospital. So I was hoping to hear from panelists on that a little bit.
Well, I can speak to that a bit, and that's absolutely correct. That there is, unfortunately, a real gap between the real life medical efficacy of cannabis that can be used in a hospital setting versus the policies and procedures that govern the hospital itself, that are typically not created by the physicians that are actually practitioners and doing the work. And I can tell you anecdotally, my brother, who's a critical care surgeon, was lamenting to me recently that he would far prefer to be able to give his patients cannabinoids than opiates, but he can't. And so he, in his role, dealing with very serious traumatic surgical issues, he is only able to prescribe opiates, and he can do that in copious amounts. And what he described is essentially all day, every day, he's prescribing significant amounts of opiates that he would much prefer to be able to replace that with cannabinoids, but he's just legally unable to. And that's, I think, a real problem, and it's a good issue to bring attention to, and something that we should address from a policy perspective. It's a really important point.
Yeah, I would just like to add that there are slowly increasing numbers of hospitals that are doing the same thing as schools and allowing parents, guardians, family to bring the drug into the hospital as long as staff aren't giving it. Even Children's in Minnesota is one of the ones that is allowing it. It's going to be a slow climb.
And I have seen it treated differently with hospice. I've seen hospice much more willing to utilize cannabinoids because essentially we're in an end of life stage anyway. And it's just an easier thing for them to justify, I think, with their own policies and procedures with regards to the hospital setting in California. So there is some movement, and there are states, I agree, that are doing that, but it's certainly not universal. And there's a lot of patients that are just being denied access through the hospital setting.
I would have to say, don't lose hope, because I did kind of squeaky wheel to my daughter's hospital and said, knock on wood, we haven't had to go in the hospital for any EEGs or any emergencies, but if she were to need it, would it be allowed? And I was told that because they are an integrative hospital and they do have doctors that prescribe it, if the doctor caring for her would agree to it, then we could, like you're saying, Joan, you may be able to administer it as the parent or caregiver. So I would say let's keep this marching battle going. We're not losing it. We just have to educate and get more laws. So.
And on that comment, Maureen, the next question I think dovetails nicely into that, and that's, is there any legislation that folks can promote to bar insurance companies from denying life insurance and disability coverage on the basis of medical cannabis use? And I don't know if there are any bills out there that folks who are on this panel have been advocating or supporting. I don't know of any immediately, but wanted to shoot that out to folks in the group.
Yeah, I would just add that not having to do with cannabis, but I know school nurses have a couple here and there have run into problems trying to get naloxone because it's much more available so that you can treat an opioid overdose. And they've been a couple of school nurses who got it on their own. Apparently their information went into a database or it went through their insurance, whatever. Long story short is they were denied life insurance because they were getting naloxone. So it's a complex problem that affects many of the important drugs that we're talking about.
Thank you. Another question is, what is the best way to present a case to my pediatrician, a request for a cannabis card for ASD?
I mean, from my vantage point, it's through honesty and just transparency about the efficacy of how cannabis may be beneficial for a child on the spectrum. I mean, it's really up to the discretion of the pediatrician. So, this is something I think requires a lot of trust, because I think a lot of physicians perceive a lot of professional risk for themselves in recommending medical cannabis for a child. And so you have to find a way to address that issue. And it may be that the pediatrician that, is great in all other ways for your child is just not the right pediatrician to discuss this issue with. And there may be a referral that goes out. There are some sort of larger network-wide issues, so that, for example, here in California, I am aware of a lot of people that have had issues with Kaiser, and it's not about the efficacy at all or the physician's own opinion on whether or not it's appropriate. It's a Kaiser policy that they just won't do it. which is really just a legal liability consideration. So I think a lot of it just really comes down to this issue of, is there a real liability that is there, and is there a way to just prevail on the pediatrician in this instance to do the right thing and to understand that it's not a huge risk, that really the risk is not giving access to the child for a medicine that helps them.
And I'll just pipe in my daughter goes to Kaiser with pediatrician. He's been very supportive, but he's not the one that does the recommendation for cannabis. But he was all for, nothing was working for Brooke. So he was all for that. But on the other hand, her neurologist at Kaiser, we tried to start with Epidiolex and get into that trial, and she was too young, didn't qualify. And that's kind of the turning point where we said, we need to try cannabis. That's our only option. And they weren't on board. And so we had to look elsewhere or get a different referral, someone that supported our decisions.
Same with me, Jana. I have to chime in. Our neuro was not on board, wanted more neuromeds, maybe Epidiolex. The naturopaths we started seeing said, no, cannabis and low carb diet, and that won our battle. So sadly, not all neurologists are on board. You have to find one that is on the same wavelength as you. So it takes a little hunting, but it's worth it. If it's life-changing for your child, it's unreal. There's nothing better than seeing your child live.
Well said. One last question, and then we're going to wrap up this panel. The last question has to do with state reciprocity, and that is, if your child has a medical card in one state, is it recognized in another state where medical cannabis is legal? Or are there special provisions or special reciprocity laws that are organized for minors versus adults who might carry a reciprocity or carry a medical card into another state where there's reciprocity permitted?
Well, it depends on that state. So with regards to the recommendation itself, it depends on the various state laws. So different states do or do not allow for reciprocity, but that's just with regards to the recommendation itself. That does not cover the actual physical transportation of cannabis or cannabis products from one state to another. So it may be that really what you're hoping for is that your recommendation from one state will allow you to go to a dispensary in another state. But that's, or to excuse the possession. Let's say if you have like an issue, you get stopped on the road and there's a search and they find cannabis in that sort of law enforcement affirmative defense context. But it is limited and it's very state dependent. So just check with your state law to see if it's relevant for your state, and then check for wherever you may be visiting to see how it's dealt with in that state.
Thanks, Joe. Thank everybody on the panel for serving today, and thanks everybody who tuned in. I do want to mention with respect to that last question, I want to urge people to check out safeaccessnow.org/travel to see kind of a comprehensive analysis of different state reciprocity programs. There's great resources over on ACE's website to check out. Again, that's safeaccessnow.org/travel. Thank you again to everybody for serving on today's panel. I think we presented a lot of great information for folks who participated and tuned in. So thank you all for making time on a Saturday to have this great discussion. I really appreciate it. And thanks to everybody who tuned in and to watch.
Thank you so much. Really appreciate it.
Yeah, thank you for having me.
Thank you.
Hello, my name is Connor Sheffield. I'm 15 years old and I'll be 16 pretty soon. I take medical cannabis, and well, the reason for that is because I've got gastrointestinal dysmotility. I've been going through some GI issues basically my whole life, and I've tried most, if not all, medications available to me, including non-FDA and non-minor approved medications. And medical cannabis was the only thing that has been consistently and actively working for me. So there was actually a period of time when I had a feeding tube because I couldn't eat normal. No other medication was able to help me, but medical cannabis has been able to make me hungry. It's been able to take away my pain, been able to take away my nausea. I used to think of it as like just like a legal way to get high instead of my parents, but now, like over the past year and a half, almost 2 years, I've just been thinking about it like medicine, you know, and I should be treated like medicine. So if you support me, if you support medical cannabis, and if you want to see medical cannabis be legalized through Congress, go to www.safeaccess.org/vote. You can make a difference just by voting.